Bem-vindo à Academia Brasileira de Direito do Trabalho. Eu sou Tereza Narras, titular da cadeira 43, e trago para vocês um programa de entrevistas com diversos especialistas da área e de outras áreas para poder mostrar o sentido multidisciplinar do nosso direito do trabalho. Vivemos em tempos de mudança e a Academia Brasileira acompanha essas mudanças. Começamos com o café da manhã da Academia e essa é uma forma mais aprimorada desse café da manhã para que vocês possam ter acesso ao melhor conteúdo e informação a respeito do mundo do trabalho, social, econômico e jurídico. Aproveitem e sigam o nosso canal no YouTube, no IGTV e no podcast. Aproveitem.
Okay, good morning to all. Sérgio Torres Teixeira here. I am a member of the Brazilian Academy of Labor Law. I right now am the chair number 33. And today in our good morning and breakfast with the Brazilian Academy of Labor Law, we will have an international guest, Christopher Albertyn from Canada. He is a professional arbitrator in labor disputes, and it'll be very interesting for all of us here in Brazil to try to understand the Canadian system of dispute resolutions in terms of labor cases. It's pretty much a mystery to most of us here in Brazil. I personally have actually no idea how a labor case would be resolved within the Canadian borders. So I think it'll be very interesting for us to hear Christopher and just try to understand the Canadian system. So Christopher, I welcome you to breakfast with the Brazilian Academy of Labor Law, and it is a great honor for all of us. And I would like for you to start just to introduce yourself so our everyone who is watching us can understand first who you are and what you do professionally. Good morning, Christopher.
Thanks very much, Sergio. So I'm originally South African. I qualified as a lawyer in South Africa. I was first a trade union organizer. I was involved in organizing African workers in the mid-70s, and I was banned by the South African government for 5 years. So I then went into law during that period and studied law by correspondence. And I qualified as a lawyer, and then I practiced when the banning order was lifted in 1981, 5-year order. I was able to then practice in my own firm, and it was a labor law firm, and we acted for unions. And then from there in the mid-80s, I was trained as a mediator and arbitrator. We had in South Africa a labor court, industrial court system, which had become somewhat discredited, and the parties, union and management, were looking for an alternative. And so a number of us were trained as mediators and arbitrators in the mid-80s, and we started doing private resolution of disputes. That became the model. And then I emigrated with my wife, wanted to be with her family in Canada. So we moved to Canada in the early 90s. And I decided when I came here as an immigrant that I would not requalify as a lawyer in Canada, but I would try and become an arbitrator and mediator. And I was lucky in succeeding with that. And so for the last, I would say, 27 years, I've been doing arbitration mediation in Canada. So I'll speak of the Canadian system as I understand it. I think to think of Canadian labor law, it's important to think of the country as really 10 different countries, because the laws, labor is a provincial jurisdiction. So each province has its own labor laws, and each of us operates really provincially. So I operate really within Ontario. I occasionally do a federal case, and the federal sector is really like another province. So you've got, but the basic structure across the country is very similar. The ways in which it's done, but the particulars are different in each province. So I'll describe from the perspective of Ontario, which is where Toronto is. And it's the sort of dominant model. Ontario and British Columbia, those are the two big models. The others tend to follow what happens in British Columbia or Ontario. The federal sector is much smaller. The federal sector is just that which is part of interprovincial trade. So that would include all the airlines, telecommunications, railways, interprovincial transportation is dealt with federally, but everything else is dealt with provincially. So, and really the big divide is between whether you are unionized or you're not unionized. So for non-union employees, I'll speak briefly of that because there's an area I don't deal with a lot. For non-union employees, your protection is in legislation. So there's the Employment Standards Act that sets the basic standards that employers have got to comply with. Notice pay, termination pay, severance pay if you are terminated. So it gives you what your rights are at work and if you leave work. That's the minimum standard is in the Employment Standards Act. And I'm still speaking about the non-union sector. If a worker has a claim, and then there's health and safety legislation, which protects workers to raise complaints about their work and to refuse unsafe work. And then there's workers' compensation. So if you're injured at work. So you're covered in the areas. If you're injured, you're covered. If your work's unsafe, you're covered, and that includes no harassment. There's an anti-harassment provision in the Health and Safety Act. So you may not be harassed at work, and employers must have harassment procedures at work. This is whether unionized or not unionized. There must be health and safety committees, also whether union or non-union. And then if you're terminated, you've got a claim, you can go to the Ministry of Labour and they will enforce your claim for you. Or if you're a higher paying employee, you can sue the employer in the ordinary courts. And then the court will work out what is your reasonable notice pay. And typically it varies between, yeah.
Just interrupt you. If you're a higher paid worker, can you go to court?
They go to court. They go to court. And so typically the normal rule is you would be paid unless there's cause to terminate you. If you leave a job, typically you would be entitled to a month's pay for each year of service. That would be if you're on the sort of managerial, higher technical level. And if you're more supervisory or blue collar work, it would be a lower amount, but it's not a fixed amount. The court decides, but the guideline would be typically 2 to 3 weeks per year if you're a more blue collar worker, and a month's pay per year if you are a sort of managerial or technical or professional. And I think the outer limit is 2 years. So if you've been there more than 24 years, typically you won't get more than 2 years pay as your severance. So that's your model if you are non-union. If you unionize, so firstly to get union rights, it's very efficient. It's a very efficient process, and quite unlike the United States. I mean, the United States unions battle like hell to get certified as the representative union. In Canada, it's much easier. You sign up the workers. If you've got 40% signed, you bring an application, and within 5 days, there is a vote. So there's very little time for employer interference. to stop the vote or to interfere with workers. And the 5 days, the Labour Board runs the vote, supervises the vote. If you succeed on the vote, you get a majority, then you've got bargaining rights. And you then enter into negotiations with the employer. There's also first contract arbitration, which means that if the employer is stalling the collective bargaining, you've got the right to ask the Labour Board to order first contract arbitration. And then an arbitrator will give you your first contract to get the relationship going, to get the collective bargaining relationship going. So that's to get your rights, you go to the Labour Board. Once you've got your rights, any disputes that arise will go to an arbitrator. So, and that's required under the Act. Under the Act also provides that you can only terminate people for a fair reason and that they're entitled to arbitrate any termination case. Or any case, any dispute.
You said that you have to have 40% of the workers in order to get certified. So is it possible for you to have like 2 different unions certified? No. Just one?
What happens is the 40% is to get your application in. Then within 5 days, on the 5th day, there is a vote. And the employer can respond and they decide who will vote, which workers will vote, who's in the unit, who's out of the unit. Managerial employees would be excluded. They have a vote. If you secure 50% or more, 50% plus 1 in the vote, you're in. The union is in. If you lose the vote, you can't bring a new application for 1 year. You've got to wait a year, and then you can bring another application. So, I think 6 months actually.
Is a union per sector, or you can have a union and you can have workers for different companies and for different professions?
I mean, the typical model in this country, like the United States, is enterprise by enterprise. There is sectoral bargaining. I mean, like, for example, public sector tends to be more sectoral. So, and that's more by agreement. So, for example, the healthcare sector, nurses will bargain one agreement for the whole province. The professional workers in the healthcare will have one agreement for the province. Construction, the building sector, construction sector, theirs are all provincial agreements. So it varies, and you can have, it depends also what the employers want and are prepared to do. So if you've got a number of different areas that you represent an employer, they may agree to bargain at a central level. That can't be, that's a matter of bargaining at what level you get to bargain. I don't personally think it's the best model. I think that the model of being able to bargain sectorally is a better model, but it's not something that you can force in this country, in Canada. Okay, so then any issue of difference between the parties within a collective agreement goes to arbitration. And then typically, an arbitrator is appointed by the parties. So just to talk about how you become an arbitrator, a lot of the arbitrators are people who worked at the Labour Board, which dealt with these certification cases and disputes between unions and management about their bargaining rights. Those disputes would go to the Labour Board. A lot of the people who became arbitrators later worked at the Labour Board. It's really like a Labour court in a way. It's called the Labour Board, but and you're appointed for, unlike a court, you're not appointed for life. You're appointed for fixed terms, and they've got to be renewed. And really, it's a function of acceptability in both communities. If any, Labour and management have both got to kind of support your going forward. Although it is a government decision, it's on the recommendation of the chair of the board. Typically, if the chair recommends somebody, the government will appoint that person. There has been a little bit of political interference, but not very much. It's occurred in particular moments in history, but mostly if the chair recommends a new vice chair to come in, a new adjudicator, the person gets appointed by the government for a period, for a fixed term. And normally people will stay at the Labour Board. Normally the terms are initially 3 years, 5 years, 5 years. It's unusual for people to stay longer than 8 or 15 years. I mean, I was there a long time. I was there 15 years. I stayed at the Labour Board, but you are allowed to do some private arbitration work when you're a vice chair at the Labour Board. You get 2 days a month where you can do private work, and you can use vacation time, your own vacation time, to do private cases, because it's much better paid, obviously, doing arbitration than being at the board. And then, so what happens normally is that when people start getting very busy in their private work, they leave the board and become full-time arbitrators. It's a transition to arbitration. Anyway, so under the arbitration, it's an expensive process for the parties in the sense that the union pays half of the arbitrator, the management pays half, and the big cost is their own legal costs for the preparation for the case, much more than the arbitrator. And so what tends to happen is they want to utilize that day of arbitration as much as possible, that the first day that you set. And so the model has developed that first day is really problem solving. I mean, I see dispute resolution as problem solving for those parties. How are we going to deal with and resolve this problem? Sometimes it requires a case, it requires evidence and a decision, but most often the focus is, how do we get a deal on this case? How do we work out a solution that everybody can live with? Okay, so maybe I'll show you, if you put up, Sergio, the slide that I showed you, the first one.
The slide, then we get slides now.
Yeah, we'll try that. Okay, so you can go to the next one, and I'll just talk about these innovations that have come about in recent years. So the themes I'm going to talk about are, firstly, dispute resolution as problem solving in an ongoing relationship, meaning it's something that's satisfactory for the union, for the employer, and for any affected worker. I'm going to speak first about mediation arbitration, the combined process, which has become the norm in our work. I'll speak a bit about expedition and how we try to speed up the cases. And this is more true nowadays with the more and more our cases now are all online. We're doing all the cases by Zoom. So I'll explain how that's affected the way we do the cases, the expedition. 3 is relationship building. I'll talk about that a little bit. And then facilitation and theme bargaining as a way of where parties are now using a third party to try and help them with the bargaining. And I'll talk about that a bit. Okay. We can go to the next one. All right, so the mediation arbitration. The first point is the parties must agree to it. Now, there's a provision in the statute that allows for this. The provision says the parties to a collective agreement may at any time agree to refer one or more grievances under the collective agreements to a single mediator arbitrator for the purpose of resolving the grievance in an expeditious and informal manner. So typically the parties agree that this is, the way they will do their case. And the mediation can occur at any stage of the process. It can be before the opening statements, after the opening statements, during evidence. The arbitrator can stop the case and say, look, I want to talk to you, or I want to speak to the union, or I want to speak to management. And you can say to them, look, this is let's talk about trying to settle this case now. We've heard the evidence, we understand what's happened. It can happen before argument and after argument. In interest arbitration over wages and working conditions, the mediation can occur before or after the presentation of the briefs. I'll talk about the briefs in a moment. And it occurs particularly after argument is complete. So when the case is finished, you will spend quite a lot of time with the representatives, working through with them what you're thinking of doing. This is what I think I'm going to do. What do you think about that? If I did that, if I did that, and chat and speak to both of them together, the union council and the management council, as almost as your team, to work out what the result will be, because an interest arbitration is seen as a continuation of collective bargaining. Then the form and method of mediation, that would be within the discretion of the mediator arbitrator. The council are really used as joint developers of the ideas of the settlement, so that when you're meeting with the council, your job as the mediator is to be exploring with them, what would this idea be like with your clients? Do you think it can work with them? What would be the problems if we did this? Could we explore this? Those kinds of ways of approaching the settlement. The purpose is to find a solution which serves all parties' interests, and it's necessary to have the decision makers in the formulation of the settlement idea. And so often, if you find that council is very reliant on a particular individual in the union or management, you bring them in and create a subcommittee to discuss how we're going to go forward with this case. So the outcome must be practical and problem solving, really. And sometimes, look, sometimes it fails and you've just got to do the case. You just got to proceed. But in virtually every case, we make an effort to see, can we get a settlement between these parties, and help them and lead them and guide them and make proposals, make suggestions, okay?
In terms of percentages, how many cases are resolved through this mediation in this initial stage? Is it very common, or usually does it go
on? 85% probably. I mean, in my own experience, I write maybe in a year, I will write probably 10, 12, maybe 15 decisions in a year, and I'm doing a case every day, you know, so I'm doing, I mean, sometimes the cases, sometimes the decision I write will appear to the parties as if it's not an agreed decision, but it will have been a decision that has been crafted with both parties, so that it goes to the workers and the bargaining unit and the management, senior management, but it's a decision that's been resolved before. So, I mean, if one includes that, maybe a bit more, but I would say the vast majority of cases, its issues are resolved. And the result of this is that parties now stack cases. So we will come to, I'll come to a case sometimes, and they will have 4 cases they'd like to deal with. And we'll work at them. Maybe we don't finish all 4. We might resolve 2, 3, and we don't get to the 4th one by the end of the day. But so parties have got accustomed to the idea that the aim of an arbitration is in the first instance to try and see if we can settle. Okay, we can move on. So the next now is, let's say we're not going to settle. Let's say we've made all our efforts to settle and we have not succeeded. What happens with the process? One is the parties often do agreed statement of fact, and that's becoming more common with the Zoom arbitrations, in that the parties will they'll prepare an agreed statement of fact in advance, and then they just argue and present the case, or we mediate just on the basis of the agreed statement of facts. Sometimes it's too much effort to get an agreed statement. You get a partial agreed statement, and the parties can call some ancillary evidence. That also cuts down the hearing to make it a more efficient process. Will says are becoming more and more common. So that means What happens with that is the parties exchange the evidence that their client will give. It's like their evidence in chief is the will say. This witness, I so-and-so, like an affidavit, saying, this is my evidence that I'm going to give. And then when the witness is called, the will say will be put to them. They'll confirm the will say. The arbitrator, everybody, all the lawyers, the arbitrator will have read the will say beforehand, so we'll be familiar with what's the content, And then what happens is there can be counsel for that witness can ask a few questions. What about this? I'm looking at paragraph 17. I'm looking at paragraph 27. Do you want to speak about that a little bit? Allows the witness to amplify a little bit, go through the will say. That's the evidence in chief. So it's very, within half an hour, you finish the witness's evidence in chief, and then it's over to cross-examination. It gives the other counsel a good opportunity to prepare the cross-examination, and it gives the arbitrator a nice statement of the evidence without having to take notes of all the evidence in chief. You've got all of that evidence available to you in the will say statements. The other thing that's becoming more common is the use of briefs. So in rights arbitration, some parties do this as an expedited process. They exchange briefs beforehand. So the union will typically, if it's a discipline case, the employer will, they normally do it on the same day. They exchange briefs on the same day. So the union sends its brief, this explaining what their case is about. The employer does the same. So the arbitrator gets the two briefs before, reads them through, reads all the relevant documents, and gets a feel of what the case is about, understands the case, so that when you come to the parties and start talking, it's very helpful for whether you want to mediate or adjudicate that case. And then there's normally no other evidence. It's just what's in the brief. And then in interest arbitration, it's the same. You get the briefs before, and then the interest arbitration is dealt with no other evidence. You just get the briefs of the parties' arguments and facts in their briefs that they're relying on. And so there's no actual oral evidence, or very, very seldom is there oral evidence in an interest arbitration. It's done in a single day. There's questions asked on the basis of the briefs. They amplify the main points they want to make on the briefs, and then the arbitrator makes a decision. The arbitrator may be sitting with two sides people. The union and management can appoint sides people, and in some industries, healthcare, for example, retirement homes, nursing homes, they use sides people. In police and firefighter cases, they don't use sides people. It's a single arbitrator. So for police and fire cases, what typically happens is you use the counsel as your sounding board. So once you've read the briefs and you're working on your decision, you'll have a conference call or a meeting with the counsel for the parties and work through with them what you're thinking of doing, the same as you would with nominees. You treat them as nominees. Speak to them, I'm thinking of doing this, what about this? I'm thinking of not giving this. I'm thinking of giving the union this. I'm thinking of giving management this. What do you think about that? What if I did it like this? What if we started it in 6 months, etc.? What if we did it as a trial? All those ideas, you use the counsel, excuse me, as your assistance in coming to that decision. Okay? We can move on.
Two questions. First, it seems to be a very cooperative system. Everyone's cooperating and they're working sort of together towards a decision, which is very interesting. And the other thing which is interesting, I thought, was it doesn't matter if you're a public servant, like you said, firemen and policemen, or if you're in the private sector. Both sides, they usually go through this system to resolve their disputes. Is that true?
That's correct. That's correct. And I think what's helpful is, I mean, the law I find is very specialized here in the sense that you've got your corporate lawyers, you've got, I mean, I'm sure it's similar in Brazil, but your labor law community, your labor, even your employment law is separate. There's some lawyers who just do employment law, which is the non-unionized sector. That's you know, like claims by managers who are fired or claims by, in all the non-union sector is employment law. Labor law is everything to do with unions and collective agreements. And that labor bar, you get union firms who only act for unions, management firms only act for management. Very, very few do both sides. There's hardly any. So these people see each other a lot, and I find they're generally very respectful with each other. They work together very collegially as a bar. So I'd say probably there must be maybe 500, 1,000 lawyers who are just pure labor work, either on the management side or the union side. So they work with each other a lot, and they get to know each other, and they build up good relationships with each other. They learn to trust each other. They learn which ones are the ones not to trust, which ones are, but majority, vast majority, are generally very helpful to the process. Think of the client's long-term relationship with the union. If they're on the management side, they're not out to just crush the union. The aim is to try and see how you can work and resolve this issue for the future. The union may need a favor on this case, management may need a favor on another case. So they tend to cooperate with each other. And I mean, that's helpful to the process. That if there's a good ethic of honesty, integrity, and bona fides. I mean, people do disclose relevant information, don't take cheap tricks against each other, those sorts of things. Okay, we can move on. So this next one, you see before we start with it, I'll go into it in detail. Let me just talk a little bit about it, maybe turn it off for a moment, and we'll turn it back on, Sergio. So, so on the more and more, what happens is people are concerned about respect and dignity in the way that they are treated. So issues of harassment, fair treatment are becoming more and more common in the cases we deal with. Discrimination cases, people feeling they're discriminated either on a prohibited ground, race, sex, gender, sexual preference, etc., whatever. So there's that area of cases are more common. But general harassment cases where people feel I'm not being treated with respect, I'm not being heard, I'm being bullied, those kinds of cases are becoming more common. So the solutions for those cases are not so obvious very often. And sometimes relationships between an employer and a union and the workers, or a particular department or particular factory or workplace, start becoming poisoned. And there's a claims by the union that this is a poisoned workplace. And that area of work is an area that some of us as arbitrators have worked in with people who are more facilitators of relationship. So I want to talk about that area a bit because it's an area of importance to union and management that's a growing area. So we can show the slide now. So the first is who's going to be involved. So what has happened is that parties now, sometimes an agreement is reached that we're going to have a relationship building exercise. We're going to do something to try and change this relationship. That's what's needed. So when you find people are accusing each other of bad faith, where you hear the union say, oh, you can't trust any of them. You can never trust them. Whatever they say, they don't do. And you hear the same from management. These guys, you can never trust them. When you start hearing that language a lot, that suggests that what these parties need is a rebuilding, is a readjustment of their relationship. They need to talk about the relationship itself. So this is the process, really, of everyone who influences the culture in the workplace should be represented or involved directly in the discussion. So what happens very often, where you've got weak leadership in management and weak leadership in the union, power centers develop in the workplace who are not bullies develop, and they occupy the space that poor management vacates. So if you've got weak management who are not exercising decisions, they're not disciplining bad behavior, the people step into those gaps. Those who enjoy the bad behavior step into those gaps and start becoming bullies and nasty to others and speaking down to some people and picking on some people and excluding some groups. So to break those patterns, you've got to have everybody involved. Those who feel victimized, those who are accused of being bullies, all of them need to be involved in this process to change their behaviors. You set rules for the conduct of the process. Among these rules are no interruptions. You listen to what everybody's got to say. No insults. You can't say to somebody, you are a lying thief, or you are a deceiver, etc. You cannot say those things in the meeting. You can say how you feel, and you can speak of your experience, but you can't accuse people. You can't bad name anybody, bad mouth anybody. Every opinion is treated as important. We listen to everybody in this process. The aim of the process is to establish respectful and productive working relationships on an ongoing basis. There's a commitment by the parties to complete the process, to go through the whole thing. Typically, it will last at least 2 days, maybe more. We normally set 2 days, sometimes 3 days for this process. There's a commitment by the union and the company to follow up afterwards. You allow the full expression of feelings and experiences. So when you ask people, you say, well, how have you been feeling about this workplace, about what's happened? You let people talk, you let them express your views, you make notes of all the points that they're making so that you can use those as things that need to be addressed. You ask them to describe experiences. What has happened? Why do you think things are so bad? And they talk through those experiences. And you find out how people were felt as a result of these experiences. All right, we go on. The next is you allow responses and you listen to those responses and apologies. I mean, some people will be amazed that their behavior had this effect on some people. They will speak up, they'll say, I never realized that me doing that had that effect on you. I'm terribly sorry, and so on. So you allow these things to happen in the process, a very helpful cathartic experience for them. You then start developing proposed remedies to the issues raised. This is where the role of the facilitator, I mean, the first part is all really psychology, and to have people who are good psychologists and good support people working with you is valuable. I'm not terribly good at all that touchy-feely stuff, you know, myself. So I generally work with a woman she's a lawyer, but her work is all in this psychological development stuff, you know. So she leads that part of the discussion. You want people who are better at that, I think, than certainly I am. Anyway, and then, but the role of the sort of lawyer, arbitrator, is to start formulating what might be the remedies of the issues, what's needed to bring about a workplace. And it will be in issues of training, issues of behavior, how you treat each other, rules of behavior, civility rules. It will be in issues of consistent discipline, that people are disciplined for wrong behavior, that it's not excessive, etc. That there are ways, there are procedures for addressing problems, and so on. And then what happens is all proposals, I mean, sometimes typically the union will like to work together to develop its proposals. Management would like to work together to develop. You allow that to happen. They develop their proposals separately. Often you bring them together, you discuss all the proposals, you clarify all the proposals, what's meant by them. You then facilitate the process of agreed language. So you see what everyone can agree to. And finally, you generally adopt the agreed objectives and you come to a kind of civility pact. This is how we're going to live our lives together in this workplace. This is how we commit ourselves that we're going to behave in future. And then you move to an action plan to implement these objectives, which is joint union and employer responsibility with assigned roles. You give specific jobs to people. So for this objective, what is needed to achieve this? You decide who will lead it, who will take the action, when will it be done by? And you have commitments to time periods that jobs must be done. There's a committee appointed, normally union management, 2 on each side. They meet regularly to see that these changes, cultural changes within the organization are going to be carried through. And then there's a follow-up with facilitators. The facilitator follow-up is that those who help this process come back maybe 3 months later, then maybe 6 months later, maybe a year later again, come back and have a meeting with the people who were part of this and any new others to work through. Are there problems? Are things working? Are things not working? Why not? To kind of readjust the relationship and to make sure that this process is succeeding. All right, we can go to the next slide.
Christopher, so it sometimes goes beyond a case, and the important thing is to try to develop a new culture within that
Exactly.
the company, right?
Exactly, Sergio. And how this comes up, you see, it often comes up in that a group, maybe 3-4 individuals, all complain, we're being harassed by our manager, and then the manager complains, these people never follow my instructions. You know, they're a law unto themselves. They're always late. They're always arguing with each other. They always give me an argument. I never get anything done, etc. For example, in a small place. And so you get a sense that this issue is not going to be resolved by simply an order, that the parties are directed to stop, management must stop harassing the workers and the workers must, follow the rules. It's not going to help anybody. They've got to work through the issues that they have and the ways they're relating with each other. So in a way, what you do is you say that the arbitration hearing itself will be suspended. You will go into a relationship building process. As part of the relationship building, the parties agree that the grievances are resolved. That would be at the end of it, they would agree as part of this civility pact or agreed objectives, they would agree the grievance is also resolved. That would be the end of the case too. So, but you often feel, I sometimes say to parties, look, we can do a quick and dirty resolution of this. We give the guy $500, an apology from management, and he goes on his way, and that's it. But we know that's not going to be a solution. He gets an apology and some money, but we know that it's not going to solve the problem, because what has been revealed in the case is a very unhappy culture in that workplace that needs to change. Some people there need to change their behavior, and they need help in doing that. So it's linking dispute resolution with the relationship readjustment, really. Okay.
That's very interesting. Here in Brazil, we have like a legal definition that separates mediation from conciliation. And in the conciliation, you have someone who's more proactive. He can like suggest solutions. He usually works with people who didn't have a previous relation before the conflict. And in mediation, the mediator, he works much more in trying to reconstruct the channel of communication, like rebuilding bridges of communication between people who had a previous relationship before the conflict, so that they can, with this reconstructed channel of communication, try to reach a decision that they both agree to, and they both think that is fine and satisfies their interests. So it's very interesting the way we have it here. But I see there that it's sort of a mixture. You're both proactive in making suggestions, and you're trying to rebuild this bridge of communication.
Exactly. I mean, it's this process that I'm describing, this relationship building, sounds much more like your mediation, right? What you've described as the mediation. Yeah. And I mean, it's not, this work is done a lot by people who are not arbitrators, this kind of work. This, you know, people who are just, we call them more facilitators, who are facilitating this. But occasionally, what I've found the weakness in those processes is that the commitments are very often not very detailed, you know. So if you get somebody who's not involved in dispute resolution, who does this kind of relationship building, the outcomes are, we will treat each other with respect, we will listen to each other, you know. It's very generalized. It's not specific plans. There will be this arrangement. This will be done on the shift system. This will be done. You said, I mean, the combination of people with experience of collective agreements, as well as experience of relationship building, what you've described as mediation, the combination of those two produces much better agreements, I think. Agreements that have more detail and have a direct impact on the workplace, rather than just a sort of a generalized commitment, you know?
Exactly. Perfect.
Yeah.
Perfect. You don't, yeah. It's not like, you're not only worried about the immediate solution, you're worried about like pacifying something that goes way beyond the borders of that case.
Exactly. And changing behaviors. And often what happens, you know, what's interesting, often, there's often those who've been dominant in this culture of no rules tended to be the more kind of bullying type. And what you want to do is to establish procedures and rules in place that limits the capacity for bullying and gives legitimate authority its authority to act, you know. That's really what you want. Yeah, so we'll move on. So this is just in a way to look at, I mean, typically bargaining is parties come forward and they make proposals. They formulate language proposals. So what happens is the union comes and says, these are my proposals. Management says, these are my proposals. This is a different model of bargaining. Now, I don't say this happens a lot, but I'll say that some parties are using this process where they would agree to a facilitation where somebody, a neutral, will come in and assist with the bargaining. So they agree upon the areas that need to be addressed rather than pre-formulated language proposals. The normal approach of bargaining is, here's all my language proposals, here's your language proposals, and we negotiate. that's fine. If it works well and it's efficient, that's fine to do it that way. But if there are big issues to address, the way a method of doing it, this facilitated method of theme bargaining, would be you agree upon the areas to be discussed. You then establish what information is needed, if any, to fully understand these issues. So let's say, for example, I'll give an example of, I'll go through this first, then I'll tell my example. The first part of that is to produce common relevant information for the issue to be discussed, to discuss what should be changed and why, discuss possible solutions to address the problems identified, discuss and address potential problems in the proposed solutions, develop consensus for the proposed solutions with suitable modifications and improvements, and then obtain mandates for those solutions, and then develop the language. Once you've got the concept in mind, develop the language, and then adopt the language. So it's a different approach. So we can stop sharing now, but this, so that's my last slide. So I'll give an example of this. I mean, I've got a case that I'm dealing with at a university where they've got a problem. You know, we don't have a compulsory retirement anymore in Canada. Do you have it in Brazil, compulsory retirement?
In the public system, yes. In the public system, at 75, it's compulsory retirement. But not in the private system. Yeah.
Private, no compulsory retirement.
No limit, no limit.
So we had the change happen in Canada about 15 years ago. It used to be 65, and now there's no limit at all. I think for judges, they still have a 75 retirement, but for anybody else, there's no compulsory retirement any longer. So the result has been that we've got this model of, you know, typically an organization should be like this in terms of age. So you've got a few people at the top in a triangle with a lot of young people coming in and moving up the ranks. What's happened in some organizations, and I'm working with a university at the moment, is they've got this structure like that. So you've got a lot of, not so many young people, you've got some young people coming in, but there's a sort of a blockage there's a huge group above age 65 who've stayed on. And really, we've got to try and find a way of making it attractive for those people to retire, to leave, you know. And so that's an example of
where there's just in Brazil, they use an expression to oxygenate, you know.
Yeah, exactly right. I mean, because the young people, there's not enough jobs for the young academics. You know, they're coming in and they can't get permanent positions because there's all this body of old academics who are sitting there at 75, 73, etc., in their departments, not moving on, you know. So we've got to find a way of doing that. And I've been helping with this process of trying to work out a method of doing it, so that we've approached it as we've tried to work out what's the concept we're going to develop with, rather than just exchanging proposals. Try to develop what's the concept in mind to encourage these people to leave, and then make it a structure in future that doesn't repeat itself. We want to make it a way that the triangle is maintained in the future, you know, and that there's a way of ensuring that the older group moves on at a certain point. Anyway, so that approach we've been trying to do in the bargaining. I've been asked to come in and help with the bargaining, and I've been trying to get the parties to move away from just exchanging proposals, but rather to develop a common concept idea. Anyway, those are the fields I thought I would cover in terms of the structure of bargaining and the sort of innovations, the MEDARB, the expedited, the relationship building, and then this facilitated bargaining. I think those are the four interesting areas that are coming up in our labor relations in Canada.
That's very interesting, Christopher. I have a few questions because we have some minutes left in this episode of the Breakfast with the Academy, so I would like to ask them. I see here in Brazil, it's very interesting. We have a law, a federal law 9307, which disciplines arbitration, and and we admit arbitration with like no resistance in terms of cases involving collective disputes when we have collective disputes, but there is a resistance in terms of individual disputes and arbitration. Our recent labor reform, it included a new legal authorization for certain type of workers, high-paid workers who receive over 2 times the biggest pension that our Social Security offers, for them to be able to place in their contract a clause where they already admit that they would prefer arbitration if they have any sort of dispute. But that is still very rare, and it's even more rare that after they have some sort of conflict, that the worker and the employer decide to go to arbitration. So there is a little bit of resistance, and I see it on both sides. I see a resistance from the employee and the employers. It's sort of like a trust issue. You know, they don't really trust the system, and there is a resistance coming from lawyers and judges also. They're very old school in the thought that, no, if you have a labor problem, take it to court. Just go to court. You know, they don't actually think about the possibility of arbitration. That's why arbitration in terms of labor cases is still very incipient, very starting up, very small here. And I think from what you said, one thing that caught my eye in terms of a difference is that how involved the unions are with the system, you know, and the union incentive. We really don't have that here, except for one or another examples. Usually, the unions don't really get involved, and some unions actually incentivize the employees to know, if you have a problem with your employer, take it to the labor court. Yeah. That is maybe one of the reasons why our labor judiciary here in Brazil is so gigantic, so huge, because it takes up such a huge load. I mean, we're talking like nearly 4 million labor cases, new labor cases per year, nearly 4 million, very close to 4 million new labor cases, which is a huge amount of cases. And I'm sure that most of them could be resolved through extrajudicial mediation, through private arbitration, but we still don't have that culture. I think we have to overcome this trust issue and just realize that these alternatives are really very interesting for the system itself. Like, I have colleagues, judges, who are resisting because they think, no, if we incentivize arbitration, that means that we'll lose power, that we'll become less important, that all these cases will go to arbitration, they won't come to the labor court, so our labor court system will become less important. And I always try to convince them it's not like a problem with numbers. You know, your importance, you don't take out and count on the numbers. I think that this system could really help to diminish the amount of cases that go to the labor courts, which will allow labor judges to dedicate more time to these cases and have speedier results. So I really have spent some time trying to work with publications and with speeches and lectures, trying to change that sort of culture. So I would like for you to just say, what do you think, like, in Canada is very positive in terms of incentivizing arbitration, that like a worker will think naturally? Is it the support of the union, or are there other factors involved?
You know, there's a duty of fair representation. So unions have to think very carefully if they don't take a case forward for a worker. And Unions can settle a case themselves without going to arbitration on the case, and they can decide not to pursue a case to arbitration. But mostly unions, if they think there's any merit to it, they will take it forward. But thinking about the issues you're raising, Sergio, I mean, one of the things would be within the court structure, because this tradition of non-union going to court, union going to arbitration, that's the Canadian tradition. And I mean, the United States, for example, arbitration has really developed a bad name. There's really two types of arbitration in the United States. The one is the union arbitration, which is small, relatively small. 7, 8, 10% of the workforce goes to that, and that is a very good system. Very similar to the Canadian, and more formalistic, much more just leading evidence, not these innovations that I've been talking about, but just regular arbitration they would do. But that's a legitimate system. The employment law arbitration in America is awful. I mean, I think there are real problems of employer domination of those processes, and there are a number of good arbitrators. There's some arbitrators from the labor system who also do the employment, and they bring integrity to the process. But there are some where the arbitrators are appointed by the employer. And so, I mean, that's distorted the system in a way. So that's a problem. But I think within your tradition, within the tradition of labor courts, these kinds of mechanisms can be used within the court too. You know, I mean, you can introduce a more med-arb approach. You can introduce the expedited approach to these kinds of cases. And I think where private arbitration is an adjunct to generally a court system, because a court system in a way is good in that it shows the power of the working class have forced, instead of paying for the cases themselves, they have the state pay for the system, which I think there's something good about that, you know. But the thing is, the problem with it is, if judges are appointed lifetime appointment, the danger with that is that the judges start acting like judges, which is basically they're not responsible to these parties. They are who they are. I'm in charge of this process and you fit in with my process, rather than the judge seeing what's important is acceptability among these parties, is to be accepted. And the point about an arbitration is if you make bad decisions and you alienate a community, you alienate the labor community or the management community, you're done. That's your career finished. And the point is, as a judge, you've got an independence. You're not dependent one case by one case. You make the right decision on the cases, but overall, it's not as important to maintain your relationship with the parties. And I think that's the part that's valuable in arbitration. You try hard to make sure that your decisions are decisions that are acceptable in the community as a whole, in the labor relations community. So, I mean, I think there is value in the idea of developing a private system where the parties have a great deal of faith in a particular arbitrator or adjudicator. So say a particular labor court judge who does very good work in a particular industry, knows it very well. That person could very well become an arbitrator of major disputes in that industry. And I mean, maybe the way to do it is that you allow some level of private work by the judges too, that parties can choose a particular judge to deal with a case and pay for that. But I think that the more important question is, how do these systems, these efficient systems of expedition, med-arb, how can one use them within the existing structure, I think is the focus more, you know.
That's interesting, because we have here what we call multi-door models, and you can have like a multi-door model, like outside the judiciary where you one of the options is to take it to court and the other options is to go the other ways. But you could have a multi-door model within the judiciary, like you said, like have like a private arbitration option where people go to court and then the judge will give them an option if they would rather go to a private arbitrator. Because so many cases, like I've been a labor judge, Christopher, for nearly 30 years, 29 years. Next month it'll be 29 years. And I always thought when I was like a first level judge in my courthouse that 60 to 70% of the cases that I would rule over were cases that were very simple, that could have been resolved through mediation, eventually arbitration. And I would always thought, like, if that did happen, then I would have gotten, let's say, 20 or 30% of the caseload, and I would have all that extra time to work on those cases, which would have made me so much more efficient. That's an argument I always use with my colleagues, because we have just so many labor cases that I don't think that there's any way for us to give the level of efficiency that our society really wants. Like a labor case here can easily, inside a court, easily take a year to 2 years to get the sentence, the first decision. Then you'll still have all the appeals time and all the further time with the execution of the sentence. And so that's just too much time. If you're thinking about a labor case where someone got fired and hasn't gotten any of the money from any of his credits, you're thinking anything over 60 to 90 days is too much time for that particular employee. And so the numbers we have really take a toll, because they take up so much of our time with so many cases that we just really can't produce as we would like.
Yeah, I mean, look, I'll give an example of a school board, one of the big school boards in Ontario. They discovered with their union that they had something like 6,000 outstanding cases. I mean, it was ridiculous. They were setting down one case at a time for arbitration. They decided on an expedited system. And then they set up a panel of, I think there are about 10 arbitrators on this panel. And they booked our dates every year, maybe 3, 4, probably 4 or 5 days a year for each of those 10 arbitrators to do expedited cases. And what they would schedule then, they schedule 30 cases a day. And I mean, they are fast. We work through them as much as we can. We try and resolve. I'm on the panel with a bunch of other arbitrators, and on my day, we go through the 30 and we work like hell to finish them. And they've reduced their backlog enormously now. They're way down as a result of just a concentrated effort at expediting these cases, the ones that can be done. I mean, some we don't settle, and those are going to go ahead to a later date, but it's quick. Half an hour each case to just get through it and discuss with the party solutions, as a way of addressing backlog like that.
I always argue that I think that the first step is to realize that arbitration and extrajudicial mediation, they aren't our opponents in terms of the judiciary. They're our allies. They
exactly
really help us and diminish this caseload, and so that we can have more time and to be more efficient on the cases we have. I think that's the first step. I think we'll get there. It's not an easy battle. It's not an easy battle. What we have to do is we have to have trade more experiences like we're doing right now. Like Christopher, I really do think you have to come to Brazil. Have you been to Brazil before?
I'd love to. I've never been to Brazil. I've never been.
You have to come to Brazil, and you have to speak within the labor judiciary structure. It's very important for us to have this sort of view, and I'm sure that you would help me and others who defend arbitration and mediation as allies of the judiciary, just with your experience. I think that it'd be really wonderful. We've already passed time here, but I really don't care, because it was so great just having having you and speaking to you and like listening to all of your experiences. So interesting. Like I am an arbitration enthusiast here in Brazil, even though I know that, like I said, we're very incipient. We're starting out in terms of labor cases, but I really do see a future for it. I see it as a system which can help the labor judiciary, which can be very interesting because, like I always said, like in terms of arbitration, you have certain advantages over the judiciary in terms of time. Usually the cases are resolved in much less time. And I think what we call confidentiality, which is very important. In our judiciary system here, Christopher, the cases are public. And so anyone can go and watch a hearing, can have a look at the case files, and because the system is that way. It's a state offered service, and so any citizen can go and look at the case. And many people don't want that. Many disputes between employees and employers, they want to have something more discreet. And arbitration offers that confidentiality clause, which you can just limit to those people. So there's a lot of advantages also. And I think that to change our culture, trading experiences and hearing people like you is a very important step. So you have to put it in your list of things that you're going to have to do within the next year or two. You're going to have to come here.
Yeah, thanks very much, Sergio. Thanks so much for having me.
Oh, it was wonderful, Christopher. I'm sure that all of our viewers are gonna see it and see it again, because it was very educating. It was very interesting. The points that were taken, and about such an important subject. So I thank you in the name of the Brazilian Academy of Labor Law, of all of our friends here in Brazil, of Teresa, who is a great admirer of yours, and so am I. Like I was telling Teresa, we have to start a Christopher Albertyn fan club here in Brazil.
Thanks, Sergio. Very kind of you, man.
Really great. Thank you so much. Continue having all the success you have as an arbitrator, and we hope to see you in Brazil, maybe in one of our congresses or seminars that we have in our Labor Academy. So
I'd love it. Thank you, Sergio. Thank you, man.
Arbitration as an ally of our labor judiciary.
Excellent. Thank you, Sergio. And it'd be lovely to see you here too, you and Teresa. We've got a conference coming up and Labor Arbitrators Conference coming in Toronto in 2022, May of 2022. So it'd be lovely if you bring a group up to that. Would be marvelous, man.
That would be. That really would be. That really would be. Okay, Chris, thank you so much for accepting our invitation, for spending this morning here, and we hope to see you soon. Okay? Thank you, my friend. Thank you.
Bye-bye.
Goodbye, and to all of our viewers. Então, finalizo então esse café da manhã com a academia, com a entrevista com o Christopher Albertyn, esse árbitro profissional do Canadá. Foi absolutamente fantástico. E então vale a pena rever e refletir sobre as suas colocações. Então, obrigado. Goodbye to all. Goodbye, Christopher. Thanks a lot.
Thank you.
Bye-bye.
Thanks, Mitchell. Bye.